In this presentation, we will discuss why it would be appropriate to issue a restriction requirement and, if appropriate, when the requirement may be issued. We will also help you identify what steps should be taken when issuing a restriction requirement. And finally, we will help you navigate Chapter 800 of the MPEP, which addresses restrictions. Please note that this class is limited to restriction of utility patent applications filed under 35 U.S.C. 111A. U.S. restriction practice does not apply to Patent Cooperation Treaty, or PCT, applications or national stage applications filed under 35 U.S.C. 371. 35 U.S.C. 101 mandates that an inventor obtains a patent for an invention falling within the statutory categories of a process, machine, manufacture, or composition of matter. That is, applicant is limited to one patent for a single invention. The requirement of one patent for a single invention implies that there should not be multiple patents for a single invention or one patent for multiple inventions. When multiple patents are sought for a single invention, issues of double patenting are raised. Note that there are two types of double patenting, statutory and non-statutory. Double patenting will not be discussed in detail here, but will be covered in a separate presentation. When a single patent application claims plural distinct inventions, possible issues of restriction may exist. As indicated earlier, this class will cover restriction. The statutory basis for restriction is 35 U.S.C. 121. Relevant rules are 37 CFR 1.141, 142, and 146. Chapter 800 of the MPEP provides detailed information on restriction. 35 U.S.C. 121 provides the statutory basis for restriction. Note the requirements for independent and distinct inventions, as well as language indicating that a restriction requirement may be issued. 35 U.S.C. 121 does not require that a restriction be made, but only indicates that the USPTO may issue a restriction requirement for an application. Therefore, the decision of whether or not a restriction requirement is made is at the discretion of the examiner. While the language of the code indicates that a restriction may be made for independent and distinct inventions, the criteria actually used is independent or distinct inventions. What is a restriction? When multiple, distinct, or independent inventions are claimed in an application, a restriction would require that applicant select a single claimed invention for examination. In order to determine if claimed inventions are independent, it is necessary to review the disclosure. If the disclosure reveals no connection between the claimed inventions in terms of design, operation, and effect, then the claimed inventions are considered to be independent. If, however, the inventions are connected in terms of design, operation, and effect, then the claimed inventions cannot be considered independent. We will first discuss independent inventions. Claimed inventions are considered to be independent if there is no connection in terms of design, operation, and effect. Just based on the information you have from the slides, can you make the case that the inventions are independent? From what we know about cash registers and motorcycles, it is clear that the design and operation of a cash register is in no way connected to the design and operation of a motorcycle. In terms of effect, the effect of a cash register is to provide and keep track of money, while the effect of the motorcycle is to get the rider from one location to another. Thus, there is no connection between the two inventions in terms of operation. Can a similar analysis be made for the second example? The process involved in painting a house would not be connected to the process of boring or drilling a well in terms of the design of the process. The particular steps involved in the process or operation, nor the end result or effect. The criteria for determining if a restriction requirement is appropriate is that the inventions are independent or distinct. We've discussed independent inventions. Now let's discuss distinct inventions. The issue of distinct inventions often involves related inventions. However, if inventions are related, then how can they be distinct? Factors to be considered are design, operation, and effect. Distinct inventions are often related in at least one of the factors of design, operation, or effect. A determination must be made that while related inventions are connected in at least one of design, operation, or effect, they are also unconnected in at least one of the remaining two factors. In this example, both inventions are directed to a cash register. Can you determine if they differ in terms of design, operation, or effect? The cash registers are related in terms of operation, as both electronic and mechanical cash registers have the similar effect of registering and calculating transactions as well as printing receipts. The operation of the two cash registers appear to be the same, as both require operation of keys to perform registering, calculating, and printing functions. However, the registers differ in terms of design. Clearly, the electronic cash register includes circuits and/or software not found in the mechanical cash register. Therefore, the two cash registers would differ in terms of design and may be considered related but distinct inventions. Restriction practice is applicable only to U.S. national applications filed under 35 U.S.C. 111. The claims of the application must be compared to determine if they describe plural independent or distinct inventions. U.S. restriction practice does not apply to international applications entering the national stage under 35 U.S.C. 371. 371 applications must be examined using PCT Unity of Invention rules. See MPEP Chapter 1800 for a discussion of 371 applications and PCT rules of practice. The basic criteria under U.S. law for a restriction are twofold. First, there must be two or more independent or distinct inventions claimed, and second, there must be a serious burden on the examiner if a restriction is not required. Unless the examiner can prove that both conditions exist, it is not appropriate to issue a restriction requirement. See MPEP 803-1. We discussed the criteria for determining if claimed inventions are independent or distinct in earlier slides. We will now address the criteria for determining if a serious burden would exist. That is, the examiner would be unduly burdened if required to examine the plural independent or distinct claimed inventions. Showing of this burden is a part of the prima facie case to be established in the office action. A serious burden may be shown to exist if the claimed distinct or independent inventions A. are separately classified, B, are recognized as divergent subject matter, or C, require a different field of search, as defined in MPEP 808.02. The areas of search for the distinct or independent inventions may be used to establish a serious burden on the examiner. For example, if an area of search for one of the claimed inventions is not required or likely to result in finding relevant art for the other claimed inventions, then the examiner may be able to prove that a serious burden would exist if a search and examination of all inventions were required. Please note that establishing the areas of search is not limited to classification fields of search, but may be based on use of differing electronic resources or the type of search query required for the distinct and independent inventions. A restriction is not appropriate unless the examiner can prove both that there are plural distinct or independent claimed inventions and that there would be a serious burden on the examiner if search and examination of all inventions were required. Both criteria must be met in order to establish a prima facie case for restriction. Therefore, if the examiner cannot prove that there is a serious burden in searching and examining, then restriction is not an option. In addition, if there is an express admission that the claimed inventions would have been obvious over each other within the meaning of 35 U.S.C. 103, then a restriction would not be appropriate. Restriction is not appropriate when claims define the same essential characteristics of a single disclosed embodiment of an invention. What constitutes the same essential characteristics of a single disclosed embodiment is subject to interpretation in many cases. Let's return to a discussion of distinct inventions. As discussed previously, distinctness is a requirement for a restriction of related inventions. Depending on the relationship of the claimed inventions, a one-way distinction or two-way distinction may be required. A one-way distinction requires only that one set of claims be distinct from another set of claims, while a two-way distinction requires that both sets of claims be distinct from each other. Generally, one-way distinction is required between related inventions that belong to different statutory categories of invention, while two-way distinction is required between related inventions that belong to the same statutory category of invention. See MPEP 806.05 for a discussion of various pairs of related inventions. For inventions to be distinct or unconnected in terms of design, operation, or effect, one invention must not be an obvious variation of another. Consider an application with two sets of claims to connectors. Each claim set corresponds to a different disclosed embodiment illustrated by separate figures. Assume that the embodiments differ only in the type of connector used, in this case, a screw and a nail. Are the nail and the screw connected in terms of design, operation, and effect? Or do they differ in terms on design, operation, or effect? While the nail and the screw may have the same effect and arguably the same operation, they clearly differ in terms of design. However, in order for the claims to the connectors to be considered distinct, the nail and the screw cannot be considered obvious variations of each other. Do you think it would be appropriate to restrict a claimed invention of a nail from a claimed invention of a screw? Most likely, no. The nail and the screw are obvious variations of connectors. Therefore, it would not be appropriate to restrict one claimed embodiment from another in this example. When grouping sets of claims together, group only those claimed embodiments that are distinct from each other. This approach should be used when grouping of any claim sets is considered, including species that are not patentably distinct. The next slides will provide details on 4 types of relationships commonly found between related inventions. 1. Process and apparatus for its practice. 2. Process of making a product and product made by the process. 3. Product and process of using the product. And 4. Apparatus and product made by the apparatus. Because the relationships are between inventions of different statutory category, only one-way distinction is required to be shown. Claims to a process and claims to an apparatus to practice or implement the process can be considered distinct if the process can be implemented by an apparatus different from the claimed apparatus or by hand. Distinctness may also be shown to exist if the claimed apparatus can be used to implement a process that is materially different from the claimed process. Again, only one-way distinctness is required to be shown. Take a moment to read this example, pausing the audio if needed. The apparatus as claimed can be used to practice another materially different process, such as applying granulate to a surface or an open bed, rather than to a conduit piping. Furthermore, the process as claimed can be practiced by another materially different apparatus, such as by a shovel and funnel, rather than a pump, including a compressor device. The next category of related inventions is a product and the process used to make the product. The criteria for distinctness requires that the claimed product can be made by a process that is materially different from the claimed process, or that the process can make a product that is materially different from the claimed product. Note that only a one-way material difference is required. The criteria for establishing distinctness between a process of making a product and the product made by the process is the same for all product claims, including a product by process claim. See MPEP 2113 for more details on what constitutes a product by process claim. Take a moment to read this example, pausing the audio if needed. Here, the claimed product is to a building kit for building a framework including frame components, connector plates, and directions. To prove that the claimed product is distinct from the claimed process, the examiner must be able to establish that the building kit can be made by a process materially different from the claimed method. Do you think that the claim to the building kit is distinct from the claimed method of forming a building framework? In the instant case, the product can be made by a prefabricated molding process, which does not require cutting or marking, for example, building blocks or stick and connector sets. Therefore, claims 1 and 2 are distinct because the product as claimed can be made by a process that is materially different from the claimed process. Now let's consider the category of a claimed product and claims to a process of using the product. A one-way material difference must be established in order to prove distinctness. In this example, distinctness can be established because the process of relaxing poultry can be practiced with another materially different product, for example, a musical instrument such as a whistle. Or the product could be used in a materially different method, for example, for playing music in a dance studio. The final category of related inventions we will consider is a claimed apparatus and a product made by that apparatus. As with the other categories we considered, a one-way material difference must be established in order to meet the distinctness criteria for related inventions. When making a restriction requirement as part of an office action, keep in mind the requirements for a restriction. The inventions, as claimed, must be independent or distinct, and there would be a serious burden on the examiner if restriction were not required. In order to meet the first requirement, the office action must set forth the reasons why the claimed inventions are independent or distinct. In addition, the office action should explain why the examiner would experience a serious burden if a restriction were not required. The office action should include use of the correct form paragraphs, which advise applicants about the appropriate method of replying to an office action, including traversal of the restriction requirement. The office action requiring a restriction other than an election of species should identify claims corresponding to the particular disclosed embodiments of the invention. Each set of claims should be associated with a particular group, with each group being directed to independent or distinct inventions. One group of the claimed inventions must be distinct or independent from another group in the same application. Hence, one claimed invention cannot be a part of two different groups. When considering an apparent dependent claim, review the claim to make sure it constitutes a dependent claim under 35 U.S.C. 112d and that it does not merely refer to another claim. The body of the claim, including active steps of a process claim, should be reviewed when grouping claimed inventions. Review MPEP 2113 when possible product by process claims are included in the application under examination. As with any other action taken, it is important to provide a clear record of the restriction requirement. A clearly articulated restriction requirement provides the best opportunity for applicant to respond to issues raised and for issues to be resolved early during prosecution. A clear and detailed written record furthers the USPTO's goal of compact prosecution. Note also that the written record could be used by courts if a patent issues from the application. In response to the restriction requirement, applicant may traverse the basis for the restriction, but a provisional election of one invention for prosecution must be made at that time. In order to comply with the principles of compact prosecution, whenever possible, the examiner should contact the attorney or agent to have an interview on the merits regarding the restriction. Request that an oral election be made with or without traverse, and in response, then issue a complete office action including any rejections under 35 U.S.C. 101, 102, 103, and 112. If an attorney or agent of record cannot be reached in a timely manner, or if an oral election is not made, then a written requirement for restriction should be included in the next office action. This would not be considered an action on the merits, as no consideration of the claims under 35 U.S.C. 101, 102, 103, or 112 is made. A 2-month statutory period is set for restriction requirements that are not part of an action on the merits. Restriction requirements should generally not be made after an office action on the merits, since a search and examination of the claimed invention has already been performed. If the claims have been searched and examined, it is difficult to establish that the second requirement for a restriction, a serious burden on the examiner, can be met. If an improper restriction requirement is made, applicant may petition under 37 CFR 1.144 requesting reconsideration of the requirement. Note that the petition may be filed any time before appeal of rejections on the merits, including after a final rejection or after an allowance. If the petition is granted, all claims withdrawn under an election with traversal must be examined. An improper restriction may result in multiple applications claiming inventions that are obvious variations of each other. Once the restriction requirement has been made and divisional applications filed, non-statutory double patenting rejections cannot be made. You should now be more familiar with the criteria to be met before issuing restriction requirements and be able to explain the basis of the requirement in the office action using the appropriate form paragraphs.
The main topics we will cover are understanding why a restriction should be made between combinations and sub-combinations usable together, and related products or processes including intermediate and final products. We will also cover how to identify, understand, and handle applications involving genus and/or species inventions, including Marcuse claims. It is important to note that this lecture is limited to restriction of utility patent applications filed under 35 U.S.C. 111A. It does not apply to PCTs or national stage applications filed under 35 U.S.C. 371. Remember that 35 U.S.C. 101 mandates that an inventor obtains a patent for an invention falling within the statutory categories of a process, machine, manufacture, or composition of matter. That is, applicant is limited to one patent for a single invention. The basic principle of the restriction requirement is that the claimed inventions must be independent and distinct, and there would be a serious burden on the examiner if restriction is not required. When claimed inventions are in the same statutory category, there are three ways they can be distinct: combination-subcombination, subcombinations usable together, and related products or related processes, which includes the special situation of intermediate/final product. We will discuss each in more detail. A combination is an organization of which a subcombination or element is a part. We use the abbreviation B specific to represent element B claimed narrowly, and B broad to represent element B claimed broadly. So, in the first example, you have a claim to the combination of A and B, wherein B is claimed narrowly, and a claim to the subcombination of B claimed narrowly. In the second example, you have a claim to the combination of A and B, where B is claimed broadly, and a claim to the subcombination of B claimed narrowly. The test for distinctness between a combination and a subcombination is a two-prong or two-way test, in that both conditions must be met to establish a restriction requirement. The conditions are that the combination does not require the particulars of the subcombination as claimed for patentability, and the subcombination has utility by itself or in another materially different combination. Here is an example of combination-subcombination claims wherein restriction is not proper. Claim 1 is an electrical cable that is a combination of a metal conductor and insulation, and Claim 2 is solely the subcombination, which is the insulation. The metal conductor is claim element A, while the insulation is claim element B. The restriction is not proper since the combination requires the details of the sub-combination, the details being the polyethylene and ethylene propylene resins. In example 2, claim 1 is still a combination of a metal conductor and insulation, and claim 2 is solely the insulation. The difference here is that claim 1 does not require the details of the sub-combination for patentability. The insulation of claim 1 is broadly claimed as polyolefin, which encompasses polyethylene and ethylene propylene resins. In this example, the omission of details of the claimed subcombination B specific in the combination of A and B broad serves as evidence that the combination does not rely upon the specific limitations of the subcombination for its patentability. In addition, the specifically claimed insulation in Claim 2 can be used in other electrical appliances other than as an electrical cable. As a result, restriction is proper. The test for distinctness between subcombinations usable together is a three-pronged test. The subcombinations as claimed must be separately usable, must not overlap in scope, and must not be obvious variants of one another. In this example, there is an aquarium in Claim 1, which is a combination of the tank and pumping system claimed in Claims 10 and 15. Restriction is proper in this example, since the subcombinations, tank and pumping system, are separately usable, they do not overlap in scope, and they are not obvious variants. When two or more claimed subcombinations are disclosed as usable together in a single combination, and can be shown to be separately usable, the subcombinations are usually distinct from each other. Another test for distinctness that can exist in patent applications is between an intermediate and final product. This is a three-pronged test that is satisfied when the intermediate and final products, as claimed, each have a mutually exclusive characteristic. The intermediate product as claimed is useful to make other than the final product as claimed, and the intermediate and final products are not obvious variants. Although only a one-way distinctness needs to be shown, the underlying presumption is that, typically, the intermediate loses its identity in the final product. In the two examples on this slide, it can be seen that the restrictable example differs from the non-restrictable example in that the coating composition of the restrictable example comprises cross-linked polyethylene glycol. As a result, polyethylene glycol, which is the intermediate product, loses its identity in the final product, the laminate in the restrictable example. In review, the claimed coating composition and laminate of the restrictable example have a mutually exclusive characteristic in that the coating composition of the laminate is cross-linked. Further, the coating composition is useful outside of the laminate, and the laminate and coating composition are not obvious variants. In the non-restrictable example, the laminate and coating composition, as claimed, do not have a mutually exclusive characteristic. MPEP 806.05J discusses the test for distinctness between related products or related processes when they are not related as combination-subcombination, or as an apparatus and product made by that apparatus. See also the form paragraphs listed here. The test for distinctness between related products or between related processes is that they do not overlap in scope, are not obvious variants, and are either not capable of use together or have a materially different design, mode of operation, function, or effect. Last topic that we will cover is identifying, understanding, and handling situations involving genus and or species inventions, including Marcouche claims. A genus or generic claim should require no material element additional to those required by the species claims. And each of the species claims must require or read on all the limitations of the generic claim. In other words, the species claims are more narrow than the generic claim. Species may be independent or related. Most importantly, species always refer to the different embodiments, that is, different examples of the invention. This slide illustrates the concept of generic and species inventions. Figures 1 through 3 are all computers, but different examples of computers. Assume this specification is directed to various computing devices. The laptop, PC, and PDA are all different embodiments of computing devices. There is no interaction between the different embodiments, and the design, operation, and effect of each is different. In other words, each invention may be seen as patentable over each other. Claim 1 generally describes a computer and is therefore the genus or generic claim. It is a generic claim because it requires no material element additional to those required by the species claims, and each of the species claims 2 through 4, due to their dependency on Claim 1, requires all the limitations of Claim 1. Claims 2 through 4 are different examples of computers, laptop, PC, and PDA, and thus are the species claims. In other words, Claims 2, 3, and 4 are drawn to species of generic claim 1. The test for distinctness between species is that each species, as claimed, requires a mutually exclusive characteristic not required for the other species, and that the species are not obvious variants. When requiring the applicant to select a species, it is called an election of species. Form paragraph 8.01 is used to set forth an election of species requirement. Brackets 2 and 4 permit the examiner to provide reasons why the species are independent or distinct and why it would require a serious burden to examine all the species if restriction were not required. A Marcouche-type claim recites a plurality of alternatives in a claim. For example, the alternatives may be usable substances or members. Marcouche claims often use language such as selected from the group consisting of A, B, and C, where A, B, and C are alternatives representing a Marcouche group. The members of the group can be species. In this example, the Marcouche group is polyurethane rubber, polystyrene, butadiene, and polyolefin rubber. Claim 1 has 3 distinct species due to the Marcouche group. Restriction may be proper when handling a Marcouche claim if there are distinct inventions and a prior art reference would anticipate the claim with respect to one of the members of the Marcouche group, but would not render the claim obvious with respect to the other members of the group. As stated previously, form paragraph 8.01 should be used to set forth the election of species requirement. While a Marcouche group may have independent and distinct inventions, if the members of the group are few in number and the entire claim can be made without serious burden, the examiner must examine all the members of the Marcouche group. Once a species in a Marcouche claim has been elected and that species deemed allowable, The examiner must extend the search to the non-elected species to determine the patentability of the claim. However, if the elected species is rejected over the prior art, examination will be limited to the Marcouche type claim and claims to the elected species. If you find art on another species, you do not need to extend search to cover all the non-elected species. When making an election of species requirement recited in a Marcouche claim, you should keep in mind that if the elected species is canceled in response to a prior art rejection, that response is considered proper. Examination of the Marcouche claim will be extended to the non-elected species to determine the patentability of the claim. The next office action could be made final if appropriate. You should now be able to recognize when a restriction requirement may be necessary for claims drawn to combination, subcombination, subcombinations usable together, and related products or processes, including intermediate and final products. In addition, you should be able to recognize situations where an election of species should be made, including Marcouche claim scenarios. Lastly, you should know what form paragraphs to use to set forth restrictions or election of species.
In this module, we will review restriction practice as covered in parts 1 and 2 and discuss more complex restriction scenarios. These include when a restriction should be lifted and the non-elected claims then rejoined and examined. We will cover such topics as whether restriction is proper per the MPEP, what a serious examination burden on the examiner entails, writing a proper restriction, and why it is important to applicants and the public not to make improper restrictions. In other words, restrictions can have consequences of which you need to be aware. Advanced topics this module will cover include linking claims practice, applicants' responses to restriction requirements, and election by original presentation. Election by original presentation addresses situations in which the examiner is not required to examine new or amended claims. If you see an asterisk on the slide, pay special attention as these signify the new topics. The fact you may make a restriction doesn't mean that you have to make one. As you become more experienced in examining, you may realize that it is not always worth the effort to make a restriction. On other applications, you may wish you had made a restriction. It is helpful to discuss the pros and cons of restriction practice with your SPE or trainer. For example, some examiners rarely make elections of species, while others make them regularly. Restriction decisions may depend on your art area. In addition to the definition of restriction and criteria of plural independent or distinct inventions and serious examination burden, this slide is also a reminder not to confuse U.S. restriction practice under 111A with PCT Unity of Invention practice for National Stage 371 applications. You will need to know how to distinguish between restriction and lack of unity and do both types of quote-unquote restrictions. Examiners should provide defensible reasons why it would be a serious burden on their part to search and examine all of the claims. Use any of the 3 standard reasons cited here as appropriate and explain why that reason applies. If you explain serious burden with sufficient specificity, then upon traversal you can point to the reasoning already provided in the restriction to rebut the traversal arguments. Setting forth a well-reasoned restriction requirement may also make applicant less likely to traverse in the first place. This is the same mindset you should develop for all your office actions. Thorough, Well-explained actions are the essence of compact prosecution and can save time and effort in the long run. There are several fact patterns that block the use of the restriction tool. It is important to understand these, though some may be rare, such as when there is an express admission that the claimed inventions would have been obvious over each other. Refer to the cited MPEP sections for in-depth discussion of when restriction is not an option. This slide refers you to the various MPEP sections which detail how an examiner goes about establishing distinctness between related inventions of differing statutory classes of invention. This slide refers you to the various MPEP sections which detail how an examiner goes about establishing distinctness between related inventions in the same statutory classes of invention. Examiners are encouraged to ask questions and look up things in the MPEP. Topics such as distinctness between related products or process, that is, the intermediate final product relationship, or the combination-subcombination relationships between claims, can be confusing. When in doubt, ask your trainer. One new concept in this module is rejoinder, which is the process of withdrawing a restriction requirement between an allowable elected invention and a non-elected invention, and examining the formally non-elected invention on the merits. Rejoined claims must still be fully examined. Rejoinder will be discussed in more detail later in this module. This slide discusses the scenario wherein non-elected process claims are eligible for rejoinder with related product claims that have been found allowable over the prior art. This is a pretty common real-life occurrence in examination. Recall from Part 2 that we use the abbreviation B-specific to represent element B claimed narrowly, and B-broad to represent element B claimed broadly. So, in the first example, you have a claim to the combination of A and B, wherein B is claimed narrowly, and a claim to the subcombination of B claimed narrowly. In the second example, you have a claim to the combination of A and B, wherein B is claimed broadly, and a claim to the subcombination of B claimed narrowly. Both of the conditions set forth in this slide must be met for distinctness between combination and subcombination claims. This is a two-pronged distinctness test. When you have claims to A and B-specific, A and B-broad, and B-specific, claim A and B-broad is an evidence claim in that it indicates that the combination does not rely upon the specific details of the subcombination for its patentability. The presence of a claim to combination A and B-specific, however, does not alter the propriety of a restriction requirement properly made between combination A and B-broad and subcombination B-specific. If a restriction requirement can be properly made between combination A and B-broad and subcombination B-specific, then any claim to combination A and B-specific would be grouped with combination A and B-broad. Even though it may initially be proper to make a restriction requirement between a combination and a subcombination, some amendments may make the restriction moot. For example, if the claim to AB-broad is deleted or amended to require B-specific, then the restriction requirement between the combination and subcombination should not be maintained. Rejoinder must be considered for non-elected combination claims requiring all limitations of an allowable subcombination claim. Although we already mentioned rejoinder in a previous slide, we will discuss it in further detail later in this module. In this example, the resins polyethylene and ethylene propylene are species of the genus Polyolefin. Claim 2 is the combination claim, as well as the evidence claim, since it shows that the limitations of subcombination Claim 3 are not required for patentability, thus meeting the first part of the two-pronged test for distinctness. Since Claim 3 broadly recites insulation, but is not limited to use on cable substrates, this is evidence of separate utility, thus meeting the second prong of the test for distinctness. The test for distinctness between subcombinations usable together is even more complicated, as there are three conditions that must be met. If applicant were to traverse and admit that the subcombinations as claimed are obvious variants of one another, the restriction between them could be withdrawn, and the admission is potentially useful in an art rejection. This slide is an example of how restriction can be proper between a combination claim, Claim 1, and more than one subcombination, Claims 2 and 3. This is an important slide defining linking claims, which have a significant impact on restriction and rejoinder practice. Common types of linking claims are A. Subcombinations claims linking multiple combination claims, and B. Genus claims linking species claims. We will discuss examples of these in later slides. The linking claims must be examined with, and thus are considered part of, the invention elected. When all claims directed to the elected invention are allowable, should any linking claim be allowable, the restriction requirement between the linked inventions must be withdrawn. In this example, the three claims are related in design in that each requires the B-specific subcombination linking claim, but they are different in operation and effect, and therefore patentable over each other. The linking claim cannot be restricted from Claim 1 or Claim 2. As a linking claim, it will be examined with the elected combination claims. This slide illustrates a genus claim linking species claims. Restriction may be proper here, but Claim 1 cannot be restricted from Claims 2, 3, or 4. An important part of your job as an examiner is to create a clear file record. In case of an allowable linking claim, you should clearly state in the record that the restriction requirement is withdrawn, even if all claims to non-elected linked inventions were canceled. You must rejoin and examine any claims to the non-elected inventions that depend from or require all the limitations of the allowable linking claims. Use Form paragraph 8.12 to make restrictions involving linking claims, unless you have a genus claim linking species inventions. Note that when the linking claim is other than a genus claim linking species inventions, the linking claims should not appear in any particular restriction group. Election of species is another form of restriction. It can be viewed as selecting a species for starting search and examination. There may also be multiple elections of species within a restriction. The examiner may issue a restriction requirement according to groups of claims and additionally require election of a species within the elected group. Usually, the first step in proposing a restriction is to sort the claims into the different groups. Be aware there may be multiple groups of the same types of claims, such as claims to two different processes. For example, a process of making a product and a process of using a product. Sometimes, examiners mistakenly put overlapping claims in different groups. If this occurs, correct the record as soon as possible. Here are some practical tips for defining groups. Be careful of product-by-process claims, as they are sometimes mistaken for process claims, when in fact they are directed to a product and should usually be grouped with the product rather than the process. While restrictions and elections may become routine with experience, The reasons for restriction should always be clearly and completely explained, in accordance with form paragraphs 8.01, 8.02, or 8.21. The rejoinder form paragraph 8.21.04 should always be included in restrictions between a product and processes or making and/or using the product. Again, it is of utmost importance that the examiner provide a clear and complete record of restriction requirements, especially since a restriction can affect the ability to make double patenting rejections in later filed applications. Examiners should attempt to obtain an oral election because it can speed up prosecution by months, and compact prosecution provides benefits to applicant as well as the Patent Office and the examiner. However, once an attempt to make an oral restriction has been made and turned down by applicant, make the written restriction. Since 37 CFR 1.142a provides that restriction is proper at any stage of prosecution up to final action, a second requirement may be made if proper, even though there was a prior requirement with which applicant complied. Restriction is not appropriate if the invention has already been searched and examined and the claims have not changed, since a serious burden would be highly unlikely at that point. Thus, restrictions after a first action of the merits are rare. Check with your SPE or trainer if you think one is appropriate. In the reply to the restriction requirement, applicant must elect one invention for examination. If applicant wishes to traverse the restriction requirement, the reply must also include a traversal with specific reasons why applicant believes the restriction requirement is in error. So, the response can be 1. Elected without traverse, 2. Elected without traverse because of an incomplete reply, or 3. Elected with traverse. But responses to election of species can be more complex. Applicants have been known to cite drawings, not claims, as an elected invention. When there is a lack of clarity on a species election regarding which claims encompass the elected species, discuss with your SPE or trainer. Applicant's traversal on restriction should be treated as any argument by applicant. The examiner should respond fully, giving responses specific to each traversal argument set forth by applicant. An examiner should not just write "argument is unpersuasive" without explaining why applicant's reasons and arguments are unpersuasive. If you decide to withdraw a restriction, which can be done completely or in part, be crystal clear on the record what restrictions have been withdrawn and what, if any, restrictions remain. If an application is in condition for allowance except for pending non-elected claims, first decide if rejoinder is appropriate. Rejoinder will be discussed in upcoming slides. If rejoinder is not appropriate and the election was made with traverse, contact the applicant for permission to cancel the claims directed to the non-elected invention. In any event, whether rejoining or canceling claims, it is helpful to notify applicant by phone regarding the status of the non-elected claims. An election without traverse makes it simpler for the examiner to cancel non-elected claims. But if the non-elected claims depend from the allowable claims or otherwise include all the limitations of an allowable claim, rejoinder may be required. Applicant may not switch elected inventions after a first action on the merits as a matter of right. An amendment canceling all claims to the elected invention and presenting only claims to a non-elected invention is considered non-responsive. Such an attempt to completely switch inventions will cause a delay in prosecution, as the examiner has to notify applicant and then wait for a response. This holds even after an RCE has been filed. If applicant presents claims in an amendment drawn to the invention being examined, you must examine those claims on the merits. If new claims are drawn to an independent or distinct invention, in other words, if they are restrictable from the originally claimed invention, then they are non-elected by original presentation, and you should inform applicant they are non-elected and not being examined. See Form Paragraph 8.04. Rejoinder is considered at allowance. It is the process of withdrawing, on the record, a restriction requirement between allowable elected claims and non-elected claims. The rejoined invention's claims are then examined on the merits before prosecution can be closed. In order to be eligible for rejoinder, a claim to a non-elected invention must depend from or otherwise require all the limitations of an allowable claim. When all the claims directed to the elected invention are in condition for allowance, and rejoinder is appropriate, even if an election was made without traverse, claims directed to non-elected species and non-elected inventions that are eligible for rejoinder should be rejoined. Applicants should be advised of rejoinder. Any amendments filed prior to final office action or allowance that depend from or otherwise require all limitations of an allowable claim will be entered as a matter of right. To be allowable, the rejoined claims must meet all criteria for patentability under all the relevant statutes. Claims presented in a continuation or divisional may be subject to a double patenting rejection if the restriction requirement has been withdrawn in the parent. If applicant elects a claim directed to a product which is subsequently found allowable, withdrawn process claims that depend from or otherwise require all the limitations of an allowable product claim should be considered for rejoinder. Upon rejoinder of claims directed to a previously non-elected process invention, the restriction requirement between the elected product and rejoined processes must be explicitly withdrawn. Applicant may choose to cancel all non-elected claims before rejoinder. In that case, the examiner does not withdraw the restriction. This preserves applicant's rights under 35 U.S.C. 121. Here is an example in which Claim 1 is a linking claim for species 1 and 2. If either of species 1 or 2 is elected, Claim 1 must be examined with the elected invention. Species 1 and 2 both require and further define the gap in the body. If the elected species and the linking claim are allowable, restrictions should then be withdrawn to the non-elected species, since the allowable linking claim is generic to that species. Here is another example of rejoinder, wherein Claim 2 contains all the limitations of Claim 1. This example continues with Claim 3 on the next slide. The examiner required restriction between Invention A, Claims 1 and 2, and Invention B, Claim 3. Applicant elected Invention A without traverse and amended Claim 3 as shown on the next slide. As you can see, Claim 3, as amended, now depends from Claim 1 and may be rejoined. Word of caution: improper restriction requirements have consequences. If the examiner is reversed in a petition decision, the examiner must then examine one or more inventions that were previously withdrawn from consideration. Also, the nullification of non-statutory double patenting as a ground of rejection or invalidity in divisional applications imposes a heavy burden on the USPTO to guard against erroneous requirements for restrictions where the claims define essentially the same invention in different language, and where acquiescence to the restriction requirement might result in the issuance of several patents for the same invention. This could mean unjust extension of patent terms and different ownership of patent rights to inventions that are obvious variants. You should now better understand how to identify and handle some of the complexities of restrictions and the rejoinder process.